This term, there have been so many cases that are 6-3, the 6 conservative justices voting one way and the 3 more liberal justices dissenting. And so I'm interested in looking at that breakdown, and when I get to read the opinion, seeing how that breakdown worked out.
So to your point, then, it does suggest that whilst we have the idea, the notion of voting day, election day, the court is saying this is the standard that's always been that has been used in most recent years, and we're not going to do away with that.
Absolutely.
It would disrupt, the question before the American people now, and this is something the president has done, is to try and, what he says, fix how Americans vote. But what the court seems to be saying is this would disrupt voting in a way that we might not recover from.
Absolutely. I haven't read the opinion. I'm sort of reading it in real time on my computer. But, I think one of the interesting things here is if Congress wants to do something like that, like radically change the way things operate, it has to do so clearly. And so by just saying election day, well, it could be interpreted in more than one way. And the question is, well, if something could be interpreted in more than one way, how are we going to look at this? And I think in the situation in which we normally think of states as having a significant amount of control over elections, if Congress wants to change that default and take over this thing that is normally left to the states, that it's going to have to do so more explicitly. We clearly say that that's its intent.
Which are the cases you think most Americans are watching that they feel affect them directly?
I think that, some of the more, there's the sort of culture wars main issue of transgender people in sports. I think that that's gotten less attention than it probably would have a few years ago, in part because it's slightly eclipsed by these executive power cases. Birthright citizenship is obviously so significant and so important, whether or not the president can, with an executive order, essentially say that unless you were born here of a U.S. citizen or someone who's here lawfully on a permanent status, you are not a citizen. I mean, that would really have huge implications. And so I think that the culture wars issue has taken a little bit more of a backseat to some of the big cases like that one.
So let's talk about, we can tell our viewers that Amy Coney Barrett wrote the majority decision, and she was joined by Chief Justice John Roberts, and then along with the liberal members of the court, Sotomayor, Kagan, and Jackson. Alito was a dissent, and so was Thomas and Gorsuch, and Kavanaugh signing on to most of what was decided. So what Amy Coney Barrett says in the opinion is that the federal election day statute set when voters must cast ballots, not when officials receive them. And the whole meaning of an election, according to what she wrote, has always been the voter's choice of a candidate, and that choice is made when voting ends, not when the mail shows up. What does that tell you?
Well, I mean, I think that that's one possible interpretation of what Election Day means. And again, it's one that's more consistent with how we've been operating and how many states have been operating. Right. As you say, it's the least disruptive of the two possible interpretations of what Election Day means. And again, this is not a constitutional decision. This is a decision about what Congress meant when it enacted that statute.
So the decision, I should point out also, I'm just reading here the same way you are, Rebecca, is very, very narrow. It doesn't actually touch on absentee voting, which is what we were talking about earlier when I mentioned the president voted, early voting or post-election counting. And more important, with regards to the Constitution, it appears to have left Congress's power over elections for another day. In other words, I guess there was on the table this decision, this question as to whether or not Congress does have full authority over the elections, and they didn't touch that part.
Right, which is typical. What you see is the court generally trying to avoid massive problems that it doesn't have to decide in order to determine the outcome of a particular case in front of it. There's a sense among the Supreme Court justices that it's better to operate in a more incremental way and, leave these bigger decisions, if they don't have to be made, for another day when they're directly in front of the court and have been briefed before the court.
All right, let's bring in our CBS News Chief White House correspondent, Nancy Cordes, who is live from the White House. Nancy, what are you hearing about these decisions and any potential reaction from the White House, if there is any yet?
Well, Adriana, I expect that the president will have something to say about mail-in voting, which she has been railing against for years and really dredging up suspicions about whether there's some kind of fraud involved, never presenting any evidence. And this has been something that has really divided the president from some members of his party. After all, mail-in voting has long been a strength for the Republican Party. And so it made Republican officials uncomfortable many years ago when the president started arguing that people needed to vote in person, that they shouldn't vote by mail, that there was something suspicious about it. At this point, he has been doing it for so long that Republican officials have stopped trying to change his mind on this front, even though he continues to claim that there is fraud, that exists not just in mail-in voting, but in other forms of voting as well. And that's part of the reason that he is pushing for legislation in Congress that would require voter ID in order for people to vote in person as well.
You know, what's interesting, Nancy, to me is the question of elections integrity is one that has been frequently raised by the president over the course of the last decade. And as you and I know, oftentimes elections are solid when he or the candidate that he endorses wins, and they are rigged when he, as he did in 2020, loses, and when people that he likes or supports lose as well. And so all of that injection into the populace has led to the point where we are now. But it is interesting that the Supreme Court, in ruling the way it did, it took one key aspect of what the president says is a problem with our elections and says, no, it's not. Or at least they're not deciding that they're not going to rule in favor of the president's point of view.
Right. And I think that simply underscores that despite all of the lawsuits that the president brought after he lost his bid for re-election in 2020, he and his legal team were never able to prove that there was any widespread fraud. And it really sort of takes me back, Vlad, to the days after he lost his bid. And I was talking to Republicans on Capitol Hill, most of whom had won their bid for re-election, and asking them, do you believe that there was fraud in the election? And they really all had to tiptoe quite carefully because they didn't want to look like they were disagreeing with the president, even as they said, no, I think my race was fine. There was nothing wrong with it. But what about the president's race? Oh, well, he has some beliefs, and that'll be litigated in court. And so it has been a challenge for elected Republican officials who, after all, do control the House, do control the Senate, they do control the White House, and yet they have been supporting the president when he claims that there is widespread fraud and that it's hurting his party somehow.
Yeah. Nancy Cordes, stand by for us at the White House. We'll obviously come to you if there's reaction from the White House or the president. But let's bring back Rebecca Roythe, our legal analyst, who's here with us in the studio. So one of the questions that seems to weave itself throughout this opinion, Rebecca, is the issue of federalism. And the court noted already that dozens of states have different ballot receipt deadlines, and the majority is essentially saying that unless Congress says otherwise, they're going to leave it to the states to decide how to do that. Is that your interpretation?
Yes, absolutely. And, in this federalism conversation, we used to have a situation in which conservatives were very pro states' rights. And you're seeing a little bit of a shift in terms of that in certain contexts. Perhaps this is one of them, at least, in terms of the president's rhetoric about voting and how he wants to control elections. But as a general matter, conservatives tend to like to allow states to experiment with different laws and rules governing certain areas, especially something like voting that has just been traditionally something that states have really had control over in this particular way.
So the other thing that I think is interesting, we haven't talked a lot about the dissent, and it does appear that as is, I guess, the norm, that the dissent has a fundamentally different view of what Election Day means, as we were talking about it, which is Alito is arguing that the election includes the receipt of those ballots received on Election Day. I guess the question for me is which is more consistent with election law precedent, the dissent or the majority?
I think the dissent, I mean, and again, I'm sort of reading this in real time, but as much as I can tell from the dissent, I think that it's trying to do a kind of originalist type reading here, and also a policy argument to say that this is a bad idea from a policy perspective. We don't, it creates a sense of illegitimacy, a concern about elections being stolen, and I think the majority is dismissing that as, again, this is not our role. I mean, sure, possibly, but that's not how we need to read this statute. We need to read the plain language of the statute, and especially in light of, as you say, what the practice has been, which is, so many states having these practices whereby they don't have all the election ballots counted on election day.
All right, we also want to talk about there's obviously other cases the president is focusing on, but the Supreme Court has already, in essence, spoken out against the president. Earlier today, they indicated that they will not hear the president's appeal in the E. Jean Carroll sexual abuse case. Remind us what that case was about and what the Supreme Court's decision to not dive into it means.
Right. So there were two lawsuits that were filed by the president against E. Jean Carroll. And this one had to do, by E. Jean Carroll against the president. And this one had to do with defamation and sexual assault, a federal court in New York. And a jury there found him liable civilly for both. And it was a $5 million verdict. The other case is still pending and going forward, which is the one that is the larger monetary remedy. And so the question before the Supreme Court, or what they were trying to get, but the president was trying to get the Supreme Court to weigh in on, were a bunch of issues, but the two main ones were that the court allowed women who were not, who were alleging sexual assault, their testimony, even though they were not the subject of this particular lawsuit. So that's an evidentiary question. And then there was another question about, if you remember, the Access Hollywood tape and the admissibility of that tape that had the president's sort of bragging about his ability to control women in certain ways and grab them, and that, he was claiming was irrelevant and prejudicial. And so these were issues that were, contentious, but the Supreme Court has decided that it's not worth it for it to weigh in these cases. And once again, the Supreme Court gets to choose which cases it hears based on, what it thinks is it's important to weigh in on. So that means this verdict stands, and the president will have to pay this amount of money to E. Jean Carroll.
So in your mind, does this decision effectively settle this question nationwide, or are there still, I guess, statutory arguments that states or even the president or political parties could raise in future litigation?
Yeah, absolutely. It will still continue to be litigated, because the Supreme Court hasn't said, by not agreeing to hear the case, they haven't said there are no issues or we agree with the way that this court came out. All it's saying is that we don't want to hear this case. We just are not prioritizing it. We're a court of limited jurisdiction, and we're only hearing a handful of cases compared to how many people file writs asking for us to weigh in. And so there is no precedential value to it determining that it will not hear this case, and future cases can come out differently. But the one thing that we know is that this case is over.
And is that same question, I guess, would apply to the decision that did come in today with regards to election law? Could the president, he continues to say the elections are rigged. He continues to say he wants the Senate to pass this SAVE Act, which would require voter ID. I mean, it may seem to suggest that, okay, once and for all, the courts have decided on mail-in ballots, but could the president, is there another way? Is there a way to get around that and bring it back to the court?
Well, yes, absolutely, because this was not a constitutional decision. This was a decision interpreting the Congress's language. So if Congress were to enact a different law, then it could, more explicitly say that this is what it wanted.
All right. So go ahead.
We're also getting breaking news about another important case that against the president, whether or not the president can fire commissioners, including the FTC commissioner and a member of the Federal Reserve Governor's Board. The Supreme Court, in these two cases, I'm told, have voted against the president 6-3. We were just talking about how important you said that these two cases were, because it focuses on presidential power and the reach that the president has using executive orders. I know you're just reading into this now, Rebecca, but just top line, what does this tell you that both of these decisions came out against the president?
This is extremely significant to me. And, I know it sort of seems like a little bit boring and technical, but it really is not, because this is the power that the president has over things that affect individual people's lives. It has to do with how much political control he could have over things like consumer protection and labor relations and monetary policy. And so what the court has done here in both of these different cases in different contexts is limited the president's power in this regard. And I think that's quite significant and is going to have ramifications in terms of other areas of control over the administrative state.
What's fascinating to me, Rebecca, is that this is just a couple of months after the court signaled that they are in favor, or at least that they ruled in favor of expanding presidential authorities. It does seem that in this case, they are drawing the line at the Federal Reserve, which is sort of interesting. And I wonder if it's that unique institution that makes them draw the line at this. And I guess the question would be, what kind of historical or constitutional principle, as you start to read in, persuaded the majority that the Federal Reserve occupies this sort of unique space in our separation of powers framework?
Yeah, so I think, again, and I haven't fully read the case, but my guess is that they didn't decide that ultimate issue yet about how different the Federal Reserve is, and really focus on this for-cause notion, because essentially what Congress has said is you can fire a member of the Federal Reserve Board for cause, and what the president was trying to do was essentially create that cause by making the Department of Justice investigate Lisa Cook for this mortgage fraud. There was no other determination. So, not having fully read every word of this opinion, I think that what they probably said was no. For cause means for cause, and you can't
Stand by,
just
Rebecca. We're just
jump
going to go
in.
to a CBS News special report, which is going to begin in
Any moment now.
any moment.
But
now.
Tony DeCopel is standing by to go over these major decisions. And I just want to update the votes for the case involving the Federal Reserve. It was 5-4, and we're now going to join.
This is a CBS News special report. I'm Tony DeCopel. We're coming on the air as the Supreme Court just ruled on a pair of major cases tied to presidential power and the question of whether the president can fire members of independent federal agencies, including the Federal Trade Commission and the Federal Reserve Board of Governors. The first case involved the firing of FTC Commissioner Rebecca Slaughter, fired by the president without cause, and the firing of Federal Reserve Board of Governors member Lisa Cook with cause. That was the second case. So let's get right to CBS News Chief Legal Correspondent Jan Crawford, who's been reading through these two rulings. Jan, good morning to you. Begin wherever you like. What do we have?
Well, we have two very important decisions on presidential power and whether or not, as you said, the president can fire not only a member of the Federal Trade Commission, but upwards of 24 other federal agencies that Congress had created to kind of be bipartisan and more independent, and whether or not he can remove a governor on the Federal the Federal Reserve Board's Board of Governors for cause without giving her any notice whatsoever. It's a mixed bag for the president in these rulings. I think, Tony, the most important ruling does concern the Federal Reserve Board. President Trump, as you said, had tried to remove Lisa Cook, saying that she had committed fraud on a mortgage application before she was nominated as governor by President Biden. He sought to remove her for that, saying he had grounds under the law to remove her. But she got no notice. She had no hearing. He announced this on social media. And the Supreme Court today, in an interim ruling in this kind of emergency application that came up to the court, said that that wasn't good enough, that the Federal Reserve is unique and different among these independent federal agencies, that Congress set it up to kind of oversee our monetary policy, and its independence is sacrosanct. And if a president is going to remove a member of the Federal Reserve, there has to be cause, and there's got to be some kind of process, a hearing and notice, again, critical to preserve the independence of the Federal Reserve Board and its role in regulating and setting our money supply. Again, this decision was written by the Chief Justice John Roberts, as was the other decision. That would involve the Federal Trade Commission, another independent, once bipartisan federal agency created by Congress in 1914. In that law establishing the Federal Trade Commission, and again, like laws governing several other couple dozen other federal agencies, Congress limited the president's power to remove commissioners, saying that they had to be staggered and they should be bipartisan. Today, the court said that violates the Constitution's separation of powers, that these executive agencies now have so much power that the president has to be able to say he's in charge of them, that the buck stops with the president because they're acting on his behalf, unlike when they were created 100 years ago, and that voters have to know who to hold accountable if you don't like what the FTC is doing. So that's that ruling, a win for the president. He can replace these members of these independent executive agencies like the Federal Trade Commission, the National Labor Relations Board, on, but not the Federal Reserve. That is different. The markets have been watching that case very closely. As you know, Tony, the president had threatened to try to fire former chairman Jerome Powell. So this now will keep the Federal Reserve independent and protected as Congress had intended, Tony.
All right, Jen, thank you very much. Let's bring in Jessica Levinson. She's a CBS News legal contributor and Loyola Law School professor. Jessica, thank you very much for being here. Rebecca Slaughter would have seemed, on the face of it, to have a better case here than Lisa Cook because she was fired for the president for no other reason other than the president saying it was inconsistent with his priorities. That's not cause, as it was written in the law. What does this mean for everybody else at all the other federal agencies?
I think this is such an important question because, as Jan said, this is about a president's power. It's not about Rebecca Slaughter and what her case specifically was, or Lisa Cook and the case that she had in saying that the government should not have tried to remove her. I think we have to look at this through the different lens, which is this is all about what does a president, this is not just about President Trump, what does any president have the power to do? And what the court says today is very consistent with what it has been saying for years, which is when it comes to the executive branch, and specifically these independent executive agencies, that the president does get to fire and hire people at will, as Jan said, because somebody needs to be able to be held accountable. The president is elected to be head of the executive branch. And so I think the point today with respect to Slaughter's case is that it doesn't matter if there was any reason, that this should be, in the court's view, up to the president to decide. And then when it comes to Lisa Cook, we're basically bubble wrapping the Fed. We're saying that's different. It doesn't look like the FTC. It doesn't look like the NLRB. It doesn't look like these other alphabet agencies because what they do is different. And so we have, I think, an acknowledgement that not all agencies are the same, at least with respect to this carve out for the Fed, where the court is saying, looks like a bare majority of the court is saying that Lisa Cook needed some process, that she needed some notice and opportunity to be heard before, in fact, the president tried to remove her. And it's important to note that the president didn't challenge the for-cause provision when it came to the Fed. Of course, that was challenged for the FTC.
All right, Jessica, thank you very much. I want to bring in Chief Washington correspondent Major Garrett. Major, in many ways, the Supreme Court has empowered this president, but in other significant ways restricted this president. And today we have another mixed decision on that front. What do you make of the politics of it?
The Federal Reserve is different. That's what the Supreme Court said. And there has to be a process by which if the president, any president, is going to fire a sitting Fed governor, confirmed for that position by the United States Senate, you have to provide that person, under all circumstances, means by which to challenge the reason that that person was fired. Because the Federal Reserve is not only central to the United States economy, not only was it set up differently than these quasi-independent agencies, it is interacting with the entire global economy. Therefore, the perception and the reality that it is free of political pressure from any chief executive has to be protected, not just judicially, but for the betterment of the entire country. The Federal Reserve, the Supreme Court, as I read this, and I believe Jan and Jessica would agree with me on this, is different. A quasi-independent agency isn't. It has connections to the executive branch, and the executive branch can reach in there and do things that, starting in 1935, the court said, no, we're going to give these quasi-independent agencies a little bit of buffering. Gradually, in court judgments since 1935, that buffering has been eroded. This is the final straw that breaks that camel's back of buffering around these quasi-independent agencies. So they're different. They are much more attuned to the whims and the attitudes of the sitting chief executive, but the Federal Reserve is not. And for those who trade and interact with the U.S. economy, they will breathe an enormous sigh of relief. The politics of it are pretty simple. Everyone in America more or less agrees, and did agree until President Trump came along, that the Federal Reserve did have this special status. President Trump tried to change that. The Supreme Court said, not so fast.
Major, thank you very much. So recapping for people just joining us, this is good news for those who value the independence of the Fed. Lisa Cook, a member of the Federal Reserve Board of Governors who had been fired by President Trump, citing alleged mortgage fraud. She had no opportunity to respond to that charge, and she denied them. She will not lose her position. The Fed is independent in a way that other agencies are not. Rebecca Slaughter's outcome is different. The buck stops with the president. Our coverage will continue on our streaming channel, CBS News 24/7, on your local news, and, of course, tonight on the CBS Evening News. Many of you will now return to CBS Mornings. This has been a CBS News Special Report. I'm Tony DeCopel in New York.
You were just watching a special report. The Supreme Court has just issued new opinions on at least 3 major cases. Those cases include the president's ability to remove an FTC commissioner or a Federal Reserve governor, and counting mail-in ballots cast after Election Day. Let's bring back in CBS News legal contributor Rebecca Roiphe. Rebecca, let's talk about those 2 cases that really focus in on executive power, the president's power, because the president is the head of the executive branch and is supposed to maintain some independence from some other parts of the government. But here, the Supreme Court justices voted in favor of the president in the case involving the FTC commissioner, but against the president in the case involving the Federal Reserve governor. What is the distinction?
So the posture of these 2 cases was different. So what essentially was at issue in the Slaughter case was these multi-member board agencies that Congress creates separate from the president, insulates from the president with these for-cause firing provisions. And there's an age-old case called Humphrey's Executor where the Supreme Court had said, yeah, that's good, that's fine. And what the court did today was to overrule that case and say, no, it's not okay. You cannot create this little fiefdom within the executive branch where the president doesn't have this kind of ability to say, no, I just don't like you, and therefore I'm going to fire you, because that's taking away his central control over the executive branch. And so they can't do that anymore. Rebecca Slaughter can be fired, as can many other members of these sorts of boards, like there's, having to do with consumer protection, having to do with labor issues. All of these boards that Congress has created as independent boards are no longer independent boards in that respect.
But what about the Federal Reserve then? Why then was the Supreme Court's ruling against the president's ability to fire Lisa Cook, the Federal Reserve governor? Okay,
so it's a little bit complicated because what the president tried to do was not to challenge the for-cause provision, because the board governors cannot be fired at will. They can only be fired for cause. And instead of saying, I don't think I should be able to fire everybody, whoever I want to, he said, I get to have full control over what counts as for cause. So that means that I can say, as in this case, hey, I direct my Department of Justice to start an investigation into mortgage fraud. Hey, by the way, she's a suspected criminal. That's for cause. I fire her. And again, I've just started reading the opinion, but I think what the Supreme Court said is that's not enough process for her. You know what? She needs to be able, under this provision, to be able to say, hey, do you really have cause? What is it? And if you're saying I committed mortgage fraud, do you have any proof of that? Which she has persistently denied. And so she was denied this power to contest. And what they're refusing to give the president here is not, they haven't said, oh, the Fed is like categorically different. What they've said is when there is a for-cause provision, it means something. You can't just turn it into at will by essentially making up something bad that this person
a whim, which is what Justice Roberts wrote in the majority. And so let's bring in, Rebecca, while you continue to dig into some of these cases, let's bring in CBS News chief legal correspondent Jan Crawford, who's joining us from Washington, D.C. So I want to focus in a little bit on that, Jan, which is this almost institutional message that it appears that the Chief Justice is sending, which he talks about. Well, we know that this is the first time a president has tried to remove a Fed governor in its 111-year history. And Justice Roberts sort of emphasized the central bank's independence, which has been a feature of American financial governance dating back to the banks that were the first and second banks that were created in this country. How unusual is it for the Supreme Court to rely so heavily on, I guess, historical practice and preserving an institution like the Federal Reserve, which it seems to be indicating is very unique amongst all the others?
Yeah, I mean, not at all with this court, which often looks to history. But, you know, I think as Jessica Levinson said earlier, what the court is doing, and I love the way she put this, the court is bubble wrapping the Federal Reserve. These are two very important decisions on presidential power. But they're saying today that the Federal Reserve is different than all these other independent, what once were bipartisan federal agencies that Congress created going back over 100 years in some cases. It's going to keep the Federal Reserve and its role in regulating and our monetary policy distinct from some of these other independent federal agencies like the Federal Trade Commission, like the NLRB, the National Labor Relations Board, and potentially upwards of 24 others. So the decision in that case, the FTC, also hugely significant because it will give presidents now power to replace people on these independent federal agencies, which Congress had established them as being bipartisan, thinking of them almost like a panel of experts to weigh in on technical issues. But the court said that obviously these agencies have taken on so much more power in the last decade that they function as a key part of the executive branch, doing powers that the president should have ability to oversee on. So that restriction on his removal power is incompatible with the Constitution and its separation of powers provisions. That is a big deal. And that is something that this Supreme Court has been signaling now going back 15 years that it believes in, that the president, as the head of the executive branch, the Constitution tasking him with enforcing the laws, has to be able to have some say over these executive agencies that exercise considerable enforcement power so that voters know who to hold accountable. If you don't like what the FTC is doing or the NLRB is doing, right now it's kind of faceless bureaucratic agencies. But from now on, voters will know the buck stops with the president. That is something that this Supreme Court has been signaling for the last 15 years. It's why President Biden was able to remove Trump's nominee and commissioner of the Social Security agency. It's why if a Democrat wins in 2028, they will be able to remove all of President Trump's nominees to these agencies. They will be in charge of the executive agencies now after today's decision. So yes, the Fed, hugely significant because obviously the markets were watching that very closely, concerned that Trump would, his efforts to fire this commissioner with some no cause, really, I mean, with cause, but no hearing or no notice, potentially could lead to a corrosive effect on the independence of the Fed. The court, again, putting bubble wrap around that, as Jessica Levinson put it so perfectly. But the other agencies now, those are under the president's power, and voters, as this court is emphasizing, now know who to hold accountable if they don't like what these agencies are doing. It stops with the president.
All right, Jan, stand by for us. We're going to bring in CBS News legal contributor Jessica Levinson. She's joining us now. Jessica, as you heard, Jan just quoted your bubble wrap comment. How much bubble wrap are we talking here? Because it seems to me from listening to all of you that the Supreme Court is not necessarily taking issue with the president's ability to fire a governor. It's the process by which that is done. So can you clarify how insulated the Fed really is?
So more than, I'm going to kind of answer the question and not by saying more than, for instance, the FTC, more than the NLRB. There certainly, I think, is an acknowledgement, as we've been talking about, and Jan laid this out so clearly, that the Fed is different because it does different things. And the Supreme Court said this actually in one of their shadow docket decisions a number of months ago. They said, well, of course, the Fed is different. And the president has acknowledged that, I think, because that four-cost standard wasn't actually questioned in this case. When it came to the FTC case, there was a question as to whether, when it comes to these independent executive agencies, or excuse me, these executive agencies, can Congress write in a four-cost standard? Today, the court, I think, in finishing a long line of cases, as Jan talked about, said no, that Congress can't include these four-cost standards. But when it comes to the Fed, The president didn't challenge that. And so how strong is that for-cause standard? I'll say, I mean, it certainly protects more than nothing in the sense that for the other agencies, it's essentially at-will employment. What are we thinking about when we think about for cause? We're thinking about some sort of negligence, some sort of malfeasance. I mean, if I were to talk to my students about this the first day of class, it would be, you did something wrong that undermines your ability to do your job. I still think when it comes to the Cook case, that case dealing with the Fed, there are some questions about, the strength of the evidence that you need, whether or not behavior that you engage in before you take office might be enough. But there, at this point, what the court is saying by a 5-4 decision is they don't think the government is likely to succeed on the merits. I don't view this as a final statement on this is what the for-cause standard always means when it comes to the Fed.
So that's the Federal Reserve, Jessica. Let's talk a little bit about something that Rebecca Royfee raised, which is that this opinion overrules this Humphreys executor precedent that has stood for some, I think, like 90 years, almost 100 years. And as you know, the court is generally reluctant to overturn longstanding precedent. So what is the majority saying as the justification for concluding that Humphrey's executor was so fundamentally inconsistent with Article 2 that it had to go? And I didn't do well in Latin. Maybe Adriana's the smart one here, but this idea of stare decisis, is that how you say it?
I don't know what you're talking about.
Which is letting a decision stand, right? What about today's decision in the court's approach to that concept is different in constitutional cases?
Okay, I'm not accepting the assumption of the question. You're both the smart ones. I love this question about stare decisis. So you're asking, right. Of course, yes, you did. Or we both got it wrong, but I will say, I say stare decisis as well, and it means respect for precedent. It's the idea that the law should be predictable, that we should be able to rely on the law, and that the Supreme Court should only overturn itself if it has a good reason for doing so. And we could spend an hour talking about the factors that the court goes through in determining when it has a good reason. Because again, the court doesn't want to make it look like the law changes every time you get a different judge on the lower court or the Court of Appeals, or there's a change in the composition of the Supreme Court. So you asked me about the FTC case and Rebecca Slaughter and how the court was able to overrule this very old precedent. And a couple of things that I think are important for people to remember. One, the precedent had already been significantly whittled away. We're talking about Humphrey's executor. In the oral arguments, Chief Justice John Roberts said Humphrey's executor stands as an empty husk. Again, in the sense of it wasn't heavily being relied upon. The other thing to remember is why. Well, back, I think it was during COVID, there was a decision called SELA law where the court already pulled back on these for-cause requirements. And so what I see here is the court being comfortable overturning an old precedent, in part because they just really haven't relied on it for that long, and in part because they think it doesn't hold anymore. They think the president has the power over the executive branch.
All right. Thank you so much, Jessica Levinson, Jan Crawford in Washington, Rebecca, who's here on set with us. We will have much more ahead about these rulings and the significant decision the Supreme Court just handed down about the legality of mail-in voting. Stay with us. This is CBS News 24/7 Mornings.
The only way to get a 360-degree understanding of America is to get out there in America. There really is no swing at all when it comes to the priorities of everyday people. We care about how secure our job is, whether we can plan on retiring with dignity, whether our kids can have a brighter future than we have today. These are the fundamentals of American life, and I think they can be again.
Why doesn't he tell Republicans, come into my office, let's hammer this thing out?
Margaret, it's a totally fair question.
Politics isn't a game. Why are you opposed to this deployment?
It's unconstitutional.
Politics is about policy. I'm a voracious consumer of information, and I'm impatient. I don't like to be spun. To be moderator of Face the Nation means bringing the most powerful stakeholders to the table to become better informed.
We don't want to accept that there's evil that walks amongst us, but it does.
You know how when you meet somebody, you can't put your finger on it, but something's not right?
You never know what anybody is capable of.
I am a serial killer who's only killed once.
Did you think when this goes public, this town's gonna be shocked?
Absolutely.
When you're dealing with a 30-year-old cold case, it seems like there's not a lot of hope.
We knew there was a monster out there and we were going to find him and get him.
Look at him just coming around the corner like that.
We started tracking the area.
When did this accident scene become a crime scene?
Police! You called him a lying liar who lies about lying.
Do you know why we're stopping you today?
What makes you so sure that you stabbed your sister while you were sleepwalking?
I never got a chance to see her one last time.
Such injustice. I can't believe they did this to her.
But no matter how hard it gets, never give up.
I'm Natalie Morales with 48 Hours. Did you have anything to do with Joanna Hunter's death?
This is a family that just wants justice.
I'm Tony DeCopel from a region at war tonight.
To tell the story,
Hello up there.
You have to be there, seeing it firsthand.
I'm Tony. I work for CBS.
Can you clarify what this war is about? How do you avoid this becoming a death trap?
This war only seems to be accelerating.
The CBS Evening News with Tony DeCopel.
And we are back with more on the Supreme Court rulings today. We were just talking about the presidential powers case, but there was also a significant decision about mail-in voting. So let's bring in CBS News Chief Washington correspondent Major Garrett. And let's remind viewers that the decision was really against what the president has been talking about and what the president has been trying to limit in terms of mail-in voting. Major, bring us up to speed.
So the Constitution, Article 1, Section 4, establishes for states that they can determine the time, manner, and place of elections. That's in the Constitution, clearly written and delineated. And so in the state of Mississippi, the legislature decided to allow mail-in ballots, if postmarked or received within 5 days of Election Day, to be permissibly counted, if everything else about that voter registration and verification matches up. Meaning you're not going to hold voters responsible, not discount their vote just because through some vagary of the U.S. Postal Service, their ballot happened to arrive 5 days later. The Republican National Committee and other litigants challenged that. The Supreme Court said, no, that law does not violate the federal statute, which indicates that on Election Day, ballots should be received and counted. This is a state adaptation. 14 states in total have made that, so Mississippi and 13 others, where there is some grace period for mail-in ballots to arrive after Election Day and be counted. Essentially, the takeaway from this decision is the status quo holds. There will be no alteration to mail-in balloting procedures, timelines, and methods for the midterm election or any subsequent election unless Congress intervenes and changes existing law at the federal level to apply to all states. That is something President Trump is clearly pushing for, but there is resistance in the House and the Senate of varying degrees to that, and the legislative prospects for that Trump agenda item are pretty bleak. But the Supreme Court basically kept what exists in Mississippi and 13 other states on the books, and no alterations will be visited upon voters or, importantly, election officials between now and the midterms.
So, Major, you know this. The president has repeatedly argued, without any evidence, that mail-in voting and post-election day ballots counting undermine confidence in elections. I just saw him do an interview a couple of weeks ago in the wake of the elections in Los Angeles, where he argued and he ranted on about, Spencer Pratt and how the elections were rigged against him. And it doesn't appear, obviously, the court is not deciding today on the underlying principle of that. But I wonder if, for those people who support the president and who think about what the president says and take it to the bank, if today's ruling leaves room for Congress to change the laws, will this effectively settle the debate, at least as it regards mail-in voting around President Trump and some of his supporters?
Well, let's just remember, in 2024 and in 2016, President Trump won in jurisdictions that have mail-in balloting. The president himself votes by mail. Mm-hmm. Those are not, by definition, examples of anti-Republican voter fraud. The president won in jurisdictions that use mail-in balloting, that have grace periods after Election Day, and he did not challenge those results. Spencer Pratt, to your point about the Los Angeles mayor's race, is also not challenging the results in the LA mayor's race. He was in second place for a fairly good number of days after Election Day, but as ballots were counted, as is permissible under California law, that were legally cast before Election Day but arrived later, he lost ground and finished third, not qualifying in the 1 and 2 runoff system that California has. President Trump has questioned those results. Spencer Pratt, the candidate on the ballot, has not, and he's not going to litigate them. He understands how the system works. California has devised its system. Mississippi has devised it. 12 other jurisdictions, states, have grace periods for these mail-in balloting. Now, the president wants to severely limit that through the so-called Save America Act. He also wants to do other things about registration and citizenship. But again, that has a majority in the House. It does not have a majority of Senate Republicans, I don't think. We haven't tested that proposition, but it certainly doesn't have the 60 votes to overcome a Democratic filibuster in the Senate. So the president, though he is intent upon seeing that legislation passed, has no visible path to achieve that. That he continues to talk about it, yes, that's true. That is a rhetorical flourish of this particular presidency. He doesn't make it true. And I just remind people, President Trump has been elected and accepted results in presidential elections in which he voted by mail and millions of other Americans in those states voted by mail. And he never called those results fraudulent, only ones he disagrees with.
So, Major, the Republican National Committee is the one bringing this case. Tell us a bit about what we know about who votes by mail. I mean, we understand that more Democrats than Republicans tend to vote by mail, but is it much of a gap at all? You just talked about how the president won in states that do allow mail-in ballots to arrive after Election Day. What do we know about who this might impact?
It is evolving, as so much in America does. I will tell you this. In the early days, in the early advent of mail-in voting, it was a Republican initiative. Why? Because Republicans and those in their consultant class realized that people who might prefer to vote by mail had homes, residences, tended to be elderly, tended to be wealthier. They were doing other things and wanted the flexibility to vote by mail. In jurisdictions like Arizona and Florida in particular, Republicans were masterminds of encouraging and essentially making sure early mail-in balloting was done by Republicans. That's how they got early edges. It tended to be Democrats who voted on day of. That has shifted in the Trump era. More Republicans now tend to vote on the day of the election because President Trump has, for various reasons, few of them rooted in any facts, said there's something nefarious about voting on any day other than Election Day. Obviously, during the 2020 election, when many adaptations were made because of a global pandemic, remember, voting in person is a highly socialized process, so election workers had to be protected, voters themselves had to be protected. Mail-in balloting was authorized in lots of jurisdictions where it hadn't been before. That was a new thing. It was an adaptation, but it worked. There were safeguards in place, and the results were the results. They've been verified not once, not twice, but 3 times in many of those contested states. So there was a acid test, if you will, of mail-in balloting in 2020. Not everything worked perfectly, but it was an enormous and successful adaptation to deal with the global pandemic. Some jurisdictions have tightened some of those mail-in balloting since. Some have kept them where they are. But what the Constitution says about this is a state matter first. The federal government can apply rules to voting broadly, and it has. but it must honor the time, manner, and place dictates of the Constitution and defer to states when they develop their own adaptations. What the court said today was, this is Mississippi's adaptation, and it's permissible.
All right, Major, stand by. I want to bring in CBS News Chief White House correspondent Nancy Cordes, who's joining us live from the White House. So, Nancy, we were just talking about the ruling with regards to mail-in ballots. I want to talk a little bit about the two cases that involved presidential power, executive power. With regards to Trump versus Cook, the president has repeatedly, as you know, you've reported this, has repeatedly in the past pressured the Federal Reserve over interest rates and monetary policy. The question, of course, for the president would be, and the administration would be, does today's ruling send a very clear signal that at least when it comes to the Federal Reserve, the court, the Supreme Court of the United States, the highest court in the land, sees federal independence as essential, the Federal Reserve independence as essential to economic stability, not just here in this country, but around the world?
Sure, and I think there are a lot of people here at the White House who anticipated that the Supreme Court would rule this way because the justices had signaled as much months, if not years ago, when they said that the Federal Reserve is a little different than other federal agencies. Whether or not the president will fully accept that and embrace that remains to be seen. Obviously, the politics surrounding all of this, Vlad, is that the president sought to fire Lisa Cook because, according to the president's critics, not so much because of these accusations of mortgage fraud, but because what he really wanted was for the Fed to lower interest rates. And even though he had pushed for the Federal Reserve chairman to be replaced, which he now has, now that his term has ended, Jerome Powell has been replaced by Kevin Warsh, who was the president's pick. But the reality is that interest rates are voted on by the Fed Board of Governors writ large. And so it isn't until a majority of Fed governors agree with the president that you're likely to see rates coming down as quickly as the president would like them to. And so Democrats on Capitol Hill had always argued that that was what was really behind President Trump's push to get rid of Lisa Cook. Incidentally, the person who had urged the president to go ahead with this was the head of the Federal Housing Financing Agency, who at the time was Bill Pulte, who actually had urged the president to crack down on mortgage fraud by a number of political individuals who he saw as the president's enemies. Bill Pulte has now been named by this president to be the acting head of the entire intelligence community. And so this is something that is going to continue to percolate. Lisa Cook has insisted that the charges of mortgage fraud are fraudulent themselves and that she has never had an opportunity to defend herself. When I asked the president about her case several months ago, he insisted that it was all out there in the open and that if any of us were good reporters ourselves, we could have found it ourselves. And so we're just waiting to hear whether the president has any reaction to the Supreme Court decision today. So far, he has not.
I'm only laughing. I'm sorry, Adria. I'm only laughing because when you read the opinion by Justice Roberts, it claims the opposite, that this is just a whim of the president's and is not based in any kind of proof or,
We are seeing reaction now from the president. Nancy, I just want to let you know the president has posted on Truth Social calling the Slaughter case a, quote, big win. He said it confirms presidential power in our country to remove executive branch officers and agency appointees or representatives under Article 2. A little later, he says it is such an honor to be the sitting president who won this historic and unprecedented ruling, one of the most important ever given with respect to presidential powers. And of course, thank you for your attention to this matter. So, Nancy, he's calling this a big win. But when you look at the three decisions that came out today, two were against the president and one was for. Net, what do you think the White House, what are in terms of the quiet conversations happening at the White House, was today a net win or net loss?
I think that the one that was for him is a big one, and it could have long-lasting implications. Because if you think about it, the Federal Trade Commission, which has 5 commissioners, 3 Republicans, 2 Democrats, is like so many other agencies that have been designed this way to be bipartisan, and this shakes all of that up. So consider, for example, the Federal Communications Commission, which is very powerful, which makes decisions about broadband, and makes decisions about broadcast licenses and internet licenses. And now suddenly, if there is no Democratic representation on that board, we don't know exactly what the Trump administration is going to do. That really changes the way debates take place and decisions get made. So we'll see how far the president wants to go with this.
Really quickly, Nancy, I mean, it's an important point that you're making there with regards to this decision, Trump versus Slaughter, because if the president can remove the FTC commissioner at will, the president has said on the bully pulpit that part of his the thing that he is intent on doing in his second term is going after people who he feels have wronged him, right? And so the question becomes, and you will know this better than us, if the president can remove an FTC commissioner at will, who else is potentially affected by today's reasoning? You mentioned the FCC, although the head of the FCC now is a Trump loyalist. But I wonder what other agencies are under the microscope.
Think about the Federal Election Commission, which takes complaints from across the political spectrum. Imagine if now, instead of a couple of Democratic commissioners and a majority of Republican commissioners, when a Republican is in the Oval Office, if it's all Republican commissioners, does that mean that only complaints by Democrats about complaints by Republicans about Democratic candidates, that those are the only complaints that really get attention? And then it flips 4 years later if a Democrat is in power. So I think that there are a lot of unknowns here, and it's not just the FTC, the FEC, the FCC, it's the National Labor Relations Board. This really could be a very far-reaching decision.
Could even be the Securities and Exchange Commission is one that I was thinking of too, Nancy. All right, Nancy Cordes, first at the White House, Major Garrett. We thank you, Jan Levinson. We thank you, Jessica Levinson. We thank you, and Rebecca Royfee here on set with us as always, my friend. We'll be back tomorrow because there'll probably be some more decisions tomorrow.
There absolutely will be. It is the last day the decisions come out. So thank you so much for being with us. Stay with us because Mugo Odigwe is standing by in San Francisco. Hey, Mugo.
Hey, guys, thank you so much. All right, let's begin with that dramatic expansion of presidential power by the Supreme Court. The High Court has expanded the president's ability to fire heads of independent agencies, but not the Federal Reserve. Let's bring in CBS News legal contributor Jessica Levinson. Jessica, thank you so much for your time today. I'm curious about your take on this ruling. Any surprises there?
So I think what we see here is the Supreme Court making a predictable decision when it comes to executive power. So the court has said that when it comes to executive agencies, like the FTC, like the NLRB, other executive agencies, that the president has that power to hire and fire those people at will, that Congress can't add in for-cause standards. But when it comes to the Fed, that's a different agency. And when it comes to the Fed, there is still this for-cause protection because what the Fed does is different. They set monetary policy. And when it came to the case dealing with the Federal Reserve, what the court said here is that the government was unlikely to succeed on the merits of its claim of trying to remove Lisa Cook. So I think what we have is the continuation of what the Supreme Court has been saying for a long time, since before the Trump administration, which is saying that when it comes to things that are clearly under the executive branch, again, like the Fair Trade Commission, that the president can hire and fire at will. Congress can't put brakes on the president. But when it comes to the Fed, that's somewhat different. And we're still adding in that for-cause standard as a protection against the whims of a president when it comes to something as important as setting monetary policy.
Yeah, and we know the court also ruled on something else today, and that is mail-in ballots. Apparently, states can continue to count mail-in ballots after Election Day. What did we learn there? When you heard that ruling, were you surprised by it?
So I don't know if she can hear me, but Jan Crawford called this.
She did.
So many other people, including myself, said, oh, I listened to oral arguments, and I said, I don't think so. I think the court is, what is the court doing? It's looking at two different statutes. The federal statute that sets election day as the Tuesday after the first Monday in November, and then state statutes that say, as long as the opinion used the word postmarked, as long as your ballot is postmarked by election day, it can still be received within a certain grace period. I'm talking to everybody from California. We have a grace period. I listened to this and I thought the Supreme Court is going to say that federal law preempts and that states can't allow these grace periods. Jan was right. I was wrong. The court said those two things can live together, that these grace periods are permissible under the federal law. What does this mean? It maintains the status quo. And we should remember, this is a decision, as I said, based on statutes, not based on the Constitution. And so if Congress doesn't want states to be able to do this, then Congress can pass under the Constitution a different statute that would prevent states from being able to do this.
Okay, Jessica Levinson, thank you so much. And now let's get to CBS News Chief Legal Correspondent Jan Crawford in Washington for us. Jan, you did say this was going to be split, these two different rulings here. So your take on the presidential power rulings?
Well, I mean, Jessica, as she always does, explained it so beautifully, and I'm sitting here just nodding my head, agreeing with her analysis. I mean, obviously, a significant day for that issue of presidential power. And this is a Supreme Court that going back, 15 years or so has been moving in this direction. And it's all about accountability in some ways. That's how they see it, that, the conservative movement has long made the argument that these agencies have gotten so powerful and they're held unaccountable. They're kind of the faceless bureaucrats, as people have put it, critics have put it. So today, the Supreme Court is really kind of definitively saying that these agencies, like the Federal Trade Commission, like the NLRB, National Labor Relations Board, potentially like the FEC, about 24, the president has the power to put his people on those agencies. And he can get rid of the people who a Democratic president had put on these agencies. And why is that important? Because the Constitution gives the president the power to execute the laws and to enforce the laws. And these agencies are acting on his behalf. So the voters need to know that the buck is going to stop with the president. That's the court's thinking on that. And that is why it benefits presidents no matter what party you're in, and why presidents like robust executive power. President Biden got rid of one of President Trump's nominees for the Social Security Administration when he took office. And if a Democrat wins in 2028, then he or she is going to get rid of all of President Trump's appointees to the FTC and all of these agencies. It's about, as this court has said, kind of restoring accountability for some of the branches, giving the president executive authority, but also voters knowing that the buck stops with the president, and that's who you take it up with if you don't like what the FTC is doing or the FEC is doing, or you got all the other, as Jessica says, alphabet agencies.
And Jan, we should also talk about the fact that the court also rejected a push by President Trump to toss the verdict in the E. Jean Carroll sex abuse case. Can you tell us more about that?
Right, and that's something that, again, I mean, President Trump has had a mixed bag with the Supreme Court. As you know, you and I have discussed many times where he is, not happy with the court one day and then happy with the court another day. So he, got some news he didn't particularly like this morning that he's been pushing back on quite a bit. But then he got the case today on the Federal Trade Commission that will give him power over these agencies. And I think you're going to see that continue tomorrow, Mugo, which is going to be the last day of the term. And the Supreme Court is going to be announcing major cases involving transgender rights and whether or not states can ban transgender athletes from participating in girls' sports. 29 states now ban transgender athletes from participating in girls' sports. Big case tomorrow, but then also maybe the biggest of them all, birthright citizenship. You and I have been talking about that one, whether or not Trump can redefine what it means to be a citizen with the stroke of a pen. I think he's going to lose that case. The court is going to say no, the president's power does not go that far. So the court's going to continue, I think, with this theme of presidential power, but Trump is going to end the day tomorrow not as happy as he is right now with this FTC ruling.
We'll see you tomorrow, Jan Crawford. Thank you so much for your time. And now to another test of the ceasefire with Iran and the chances for a lasting peace. Both sides traded strikes just over the weekend. Iran launched drone and missile attacks targeting U.S. military sites in Bahrain. A U.S. official says American assets in the region were not damaged, but a drone struck an apartment block in Bahrain. Luckily, no injuries were reported. Now, this attack came a day after the U.S. carried out strikes on Iranian missile and drone sites. The strikes were in response to Iran's attack on a ship in the Strait of Hormuz just last week. U.S. Central Command says U.S. Navy and Air Force fighter jets struck 10 Iranian military targets near